I'd like to welcome everybody to the April 30th, 2014 City of Rapid City Legal and Finance Committee. The first order of business is the roll call and the termination of a quorum. Here. Thank you. Up next, we have the adoption of the agenda. Do we have any additions or deletions from the agenda? Does anybody have anything they want to add to the agenda? Entertain a motion to adopt the agenda.
So moved.
Motion by Laurenti, second by Peterson to adopt. All in favor?
Aye.
Opposed? Motion carries. Up next is general public comment. Now is the time for members of the public to discuss or express concerns to the council on any issue not on the agenda. Action will not be taken at the meeting on any issue not on the agenda except for placement on the agenda by unanimous vote of the council members present. I have no current speaker request forms or anything for general public comment. Does anybody wish to speak on any of these items not on the agenda? Okay, I'm going to move on to consent items numbers 1 through 8. I'm now going to open public comment on items 1 through 8. I have no speaker request forms on any items 1 through 8. Does anybody have anything they wish to speak on those items? None appearing. I'm going to close public comment on items 1 through 8. Now move on to consent items 1 through 8, and I will recognize any council member that wishes to pull any item from the consent calendar. None appearing. I'll entertain a motion to approve.
Second.
A motion to approve items 1 through 8. Any further discussion? All in favor say aye.
Aye.
Opposed? Motion carries. We're on to non-consent items number 9 through 13. I'm now going to open public comment on items number 9 through 13. I have one speaker request form for Mr. Jeff Collins for Andrew Severson on item number 10. Sir, if you would step to the podium, please. The green light says you have 33 minutes, 30 seconds is the yellow light, and red light, please. Would you wrap up your comments? And please identify yourself for the record.
Thank you. Jeff Collins. I'm the attorney for Dr. Andrew Severson. We've submitted a memo with some documents regarding asking for interpretation of a 1993 agreement that Dr. Severson entered into with the city with regards to development of his property along Park Drive. I think it's fairly laid out what Dr. Severson's position is, what we're asking the city to do. The agreement is not well drafted. It wasn't done by anybody here, but it's open to several interpretations, but a reasonable interpretation is the one that Dr. Severson has proposed, wherein there's 2 tracts of land Dr. Severson owns, Tract 2 and Tract 4. The document itself, the agreement, talks about him being the owner or discussing what will happen to Tract 2 of his property. It's silent as to Tract 4. The document lays out if Dr. Severson ever should develop his property, the assessment he would be charged to do that by the city. This arose out of conflict over putting Park Drive in 1993. There was a dispute. Dr. Severson and his sister were challenging Park Drive, challenging assessments, challenging many things. This agreement was to resolve those issues. Our request is that this agreement be, as it's shown on its face, that the assessments to be made to Dr. Severson, if he develops this property, apply only to Tract 2. The agreement does not talk about Tract 4. So our position is Tract 4 is not encompassed by that agreement, not subject to those assessments. In addition, there's been Lot H, H lot, which has been, the city has taken for its purposes, which is not really addressed in the agreement, but the city has the power to do that. We're not challenging that, but he was not compensated for that. Utilities have been placed without proper easements being placed upon his property to acknowledge that, and again, he was not compensated for that. Those seem to be included as part of that agreement, that he was going to allow that, sign the proper documents to give that transfer to the city, legal title to Lot H, and to allow the easements upon his property. So our compromise, or what we're asking the city to do, is recognize that agreement, not assess Tract 4. In exchange for that, Dr. Severson will then sign whatever documentation under the agreement is required to properly place easements upon the property and to transfer legal title to Lot H to the city. So that's what we're asking the city to do. Thank you.
Thank you, sir, and you'll be available for questions when that item comes up, I assume?
I will.
Thank you. I have no further speaker request forms on items number 9 through 13. Does anybody wish to speak on any more of those items? Sir, would you please approach the podium, identify yourself, and identify the item you wish to speak on? You have 3 minutes, please.
My name's Aaron Johnson. I own Shotgun Willie's, and I'm on item 13 about the amendment to the ordinance. It's been, and I'd like to state, first of all, thank the mayor's office for calling me and informing me that there was going to be some stuff come up to this, and I really do not know how to go about this. I know this is the first reading. I would like to know what happens from here as far as the ordinance goes, I guess. I mean, I'm not real versed in this.
I'm sure we can, and when we get to that item, sir, we can address your concerns with the city attorney and explain the procedural
So
aspects of
I'll
that.
have a
That's
second
okay?
chance to speak.
Yes, we can ask you questions at that point, but if you have anything you'd like to say at this point for us to consider.
Well, I'd just like to inform the council or committee here that, you know, that what they're wanting to do with the door on this ordinance here, there was one violation out of 250 some compliance checks. So I just kind of want to make that, you know, I don't think there should be an ordinance change on one violation. Also, the other deal is they're trying to hold the licensee, myself, responsible more so as how I interpreted it, what they had done for the responsibility or for the actions of the other people. They want to hold me responsible for the actions of what the dancers do, and I don't think that's quite right. So.
Okay. Well, if you'd stand for questions, sir, I'm sure there might be some questions that come up for you if that item comes up. Thank you. Okay, no speaker request forms or any more people wish to speak on anything else. I'm now going to close public comment on items numbers 9 through 13. And I seem to have lost there we go. Oh, sorry. Well, yeah, he's speaking on an item. He's up next. Does anybody else wish to speak? Okay, no. Ben Snow, we're going to recognize you now for item number 9, Economic Development, Rushmore Region Branding and Marketing Initiative.
Thank you, Mr. Chair. So enclosed in the packet for Legal and Finance, there are 3 documents. The first is a project history and overview for the Rushmore region. This has been a regional marketing initiative that we've been working on for the better part of the last year and a half, and it's now coming to the final stages. The overview memo indicates that we're going to do a brand launch on April the 25th. That was last Friday. That date has been pushed to the middle part of May, but everything else in here remains unchanged. What we're asking for Rapid City to do is to sign on to this diplomatic code, or code of conduct as we're calling it here in the 2-page document that's got the new Rushmore Region marketing logo at the top of it. And then there's a resolution which has been circulated throughout all of the communities throughout the Black Hills to date, assuming Rapid City adopts this today, and then at the City Council this upcoming Monday, the 3 largest communities within the Black Hills will have signed on to this code. That wouldn't be Rapid City, Sturgis, and Spearfish. And the request has been made for all of the other communities throughout the Black Hills to do likewise. And for the communities in Pennington County, I will be making presentations to Wall and Box Elder, for example. So the request stands that Rapid City adopt this code of conduct as it relates to generating prospect leads into what we're calling the Rushmore region of South Dakota. And all it basically means is that we're going to have more sharing that take place here within the region. It does not preclude any economic development organization from continuing to market their respective communities just as they have done historically. But what this does say is any new prospect leads that are generated due to these regional marketing efforts will be shared amongst all of us as partners within the region. And I'll stand available for any questions if you have any.
Thank you, sir. Okay, we're now on to item number 9. Does anybody have no speaker requests or no? I already did. I've already read in the item. I can read it again. We're on 9. Mr. Laurenti.
Thank you, Chair. And Ben, if I could ask you a question, please. And really, it's probably just to get your insight on what you're doing here. But can you talk about how this is going to be competitive advantage? What's the big positives for Rapid City in joining a regional group of municipalities? What's the advantages for us doing that, if you can tell us that?
Thank you for that question. The advantage is when you, in economic development, if each community is too parochial, what happens is your story is not as robust. We all know that the Black Hills story, or the Rushmore region as we're going to be telling it, is a more compelling story when you're talking to external audiences, people that may not be that familiar with our region. So there's two dimensions I guess I would underscore. First, if each community was just to go after marketing efforts on its own, independent of our neighbors, the bang for your buck is not going to be as powerful as if by banding together as brothers and sisters in trying to shine, as I've used this metaphor before, really trying to shine a searchlight on the Rushmore region. The upside to Rapid City is no different than the upside for Spearfish or Sturgis or any other community within the region. And that is, as more people begin to look at the region as a viable location for business, the spillover effect as those dollars, that capital investment, those jobs ultimately come into the region, then those dollars begin to pass throughout the region. They move over municipal boundary lines, they move over county boundary lines. And so really understanding the economics of our region, it makes a ton of sense that if we market it as a region, then the deal flow we get coming from audiences outside of the region would be greater than if each community was to just go it alone.
Thank you very much.
Does that answer your question?
It does answer my question. Thank you.
I still have no motion on the floor. I have a motion approved by Peterson, second by Laurenti. Any further discussion? All in favor say aye. Aye. Motion carries. Item number 10 is a request of Dr. Andrew Severson for an interpretation of the 1993 agreement for the city. Chair recognizes City Attorney Joel Andean.
Thank you, Mr. Chairman. As Jeff stated, there was an agreement entered into in 1993, and what happened is the school decided to build Southwest Middle School and the elementary there, and they needed to extend Park Drive through to Corral Drive, and they needed it done rather quickly. A lot of the property owners along the extension were not ready to develop their property and didn't want to contribute to the cost of it at that point. So a compromise was reached whereby the share of payment was deferred until they actually developed their property so they could sell lots and generate the revenue necessary to pay for their share of the street. In addition, the city created a tax increment district which helped subsidize the cost of the road. So the landowners along the road weren't even expected to pay their full share of the cost of that street. And that was done in an effort to get the street done more quickly and make it more palatable. I think at the time, Dr. Severson really wasn't in favor of it, but he ultimately signed the agreement. The real question in front of the council today and on Monday night is the agreement in one area does not reference Tract 4, but it's very clear from the discussions, the minutes at the time, the purpose of the assessment or the fee was for the whole frontage. And that's the way all the property owners were. They were going to pay per the frontage. Tract 4 is the larger of the two parcels. So essentially, if we don't collect the fee for Tract 4, then several $100,000 of reimbursement is going to be lost. Now, on the other hand, it's been 20 years. It's not like that's money that, this has been a long time, so it's not probably a loss we're going to really notice. But at the same time, when this was entered into, there were several $100,000 more dollars that we thought we were going to receive at that time. There will be a question, a legal question, and I firmly believe Dr. Severson will sue the city if we don't accept his interpretation and only assess him for Tract 2. We believe we have arguments to make, but that does not mean a court won't decide he is only responsible for the assessment of Tract 2. We did, based on the documents, offer to sit down and try to negotiate something in between what we believe the total assessment for the agreement on Tract 4 and Tract 2 would be, to bring back to the council and ask for a compromise. Really, Dr. Severson's position has been, no, I'm only going to pay on Tract 2, and further brought in the easement question because unfortunately at the time that the plats were created and the road was dedicated, the easement documents weren't actually filed on the property and the H-lot wasn't filed. But in the agreement, as Mr. Collins alluded to, it is referenced that as part of that agreement, he will provide all necessary easements and right-of-ways. So I believe that if it goes to court, we can seek enforcement of that provision. The absolute worst case scenario would be we only get the assessment on lot 2 or tract 2, and it's found that our utilities aren't within a valid easement. And then we would have to probably condemn the easements, and that would require additional compensation. The council for Monday night needs to decide whether or not you want to seek to have the agreement enforced for the entire property owned by Dr. Severson, or if you want to accept his proposal, which is to only assess him for tract 2 per the agreement, and then he will sign over the easements and the right-of-way document necessary, title to the H-lot that was referenced by Mr. Collins. If you choose not to accept, I imagine this will end up in litigation. It's probably something our office will handle internally, and we will seek enforcement or that he provide us with the necessary documents and deeds for the easements, and that we are able to assess both Tract 4 and Tract 2.
Thank you, sir. And Chair recognizes Alderwoman Charity Doyle.
Question for Mr. Landine, if I may.
By all means.
Mr. Landine, I noticed that the only thing we have linked has been supplied by Mr. Collins. You've referenced meeting minutes, et cetera. We don't have any of that documentation, nor do we have the original agreement. Would it be prudent to...
I can provide you with the original agreement. I had actually intended to provide you with something prior to Monday night and a summary similar to what I've gone over. The minutes, I would have to go back. Carla Cushman, my office, who's on maternity leave, was actually working on this. So I will say that between now and Monday night, it's going to be hard to pull all the minutes. Although this has been dragging on for several months, I'm sure Dr. Severson would like to get it resolved, but if we could continue it for 2 weeks, if you really want the minutes from the time or the discussions, then I can have more time to collect some of those documents out of our file, the relevant documents, and provide them to you prior to the next meeting. I shouldn't have any problem providing you with the actual agreement and, again, a summary if you want one of what the city's position is. I think it might also be beneficial to have a discussion in executive session, discuss maybe more in more detail how we view the chances of success on the merits and things, and some of the deficiencies maybe we see in some of the good points that we have that probably aren't highlighted in the documents that Mr. Collins has provided.
Well, I would appreciate that because I think it would be fair. Right now we only have something from the petitioner's attorney and what's in your head, not anything concrete. So I mean, for me, I'd rather do my homework and see what we have.
Well, if you look through the materials, Mr. Collins did provide, we've had some written correspondence kind of laying out our position and laying out their position. So there is correspondence from both sides in that, and the letter from, I believe that was drafted by Carla, did lay out the city's position in response to their arguments.
I'd like to see the supporting information, though.
Okay.
If at all possible. Thank you.
Chair will recognize Alderwoman Bonnie Peterson.
Make a motion to continue for 2 weeks. Well, no second.
Second for discussion. We have a motion by Peterson, second by Doyle. You have the floor.
I think, we could go ahead and just continue it or without recommendation to Monday night and have the executive session, but it sounds to me like our attorney probably needs a little bit more time to to work on it, so that's why I was suggesting that we have continue it for 2 weeks.
Mr. Landine, do you agree with that
I would
assessment?
suggest you take it to Monday night without recommendation, and after executive session, maybe we can have a discussion. You can decide whether or not you want to continue it for more information, or you want to grant the request, or just deny it and assume that we're going to end up in litigation.
Okay, I'll withdraw my motion.
Is that okay with the seconder? Okay, we now currently have no motion.
Move to the next council meeting.
I have a motion by Laurenti, second by Wright, to move to the next council meeting without recommendation. Any further discussion on this item? All in favor say aye. Aye. Motion carries. Sir, this will appear on the non-consent items, just so you know. Okay, on number 11, introduction and first reading of ordinance 5991 to amend chapter 17.16 of the Rapid City Municipal Code to allow a pet store as a conditional use in the central business district.
Move to approve.
Motion by Laurenti, second by Peterson to approve. Any further discussion? All in favor say aye.
Aye.
Motion carries. Item number 12, appeal of the historic signboard denial at 601 Columbus Street. We have a motion to approve the appeal. Is that correct? Is that correct wording, Mr. Landine? Motion to approve the appeal is the correct wording? Okay, and second by Laurenti?
Yes.
Mr. Chair?
Further discussion by, Chair recognizes Vicky Fisher.
Thank you. Just a clarification on the summary memo that's attached, it identifies that the height of the overall signage is 54 inches. In actuality, it's 60 inches. Please note, though, that the LED portion of the sign has not changed from what it's been identified in the memo. I just wanted to make sure that you take action on the right measurements.
Thank you. So noted. Has everybody got that? Everybody's clear? Chair will now recognize Charity Doyle.
Thank you. I have a question for Crystal McKee, if I may, and
By all
if
means.
she's willing to approach the podium.
Ma'am, if you could just identify yourself for the record, please.
I'm Crystal McKee, the president of the Performing Arts Center of Rapid City.
Thank you, Crystal. The question I have is relevant to the layout design of where that sign would be located. And the concern that was brought to me is that it's placed at the entrance of the school as opposed to the entrance to the theater.
Correct.
And why would you be requesting that location?
We'd be requesting that location because, A, it's more visible. The back of the school is really an alley, the actual entrance to the Performing Arts Center. But that is the entrance to the Historic Theater as well, which the Performing Arts Center occupies.
Okay, so it's not the new addition to the west?
Correct.
Okay.
It is the Columbus Street entrance, the Historic Theater, and also the main entrance to the school is on that same street.
Okay. And can you just explain a little bit about what your intentions are with the monument signs? I'm sure this is going to garner some debate on Monday night.
As far as its usage?
Yeah.
Okay, yes. The sign, as far as the LED portion, will be used to list activities that will happen at the Performing Arts Center. All performances either in the Studio Theater or the Historic Theater. Any other upcoming events, any other rentals that are coming through. All of our coalition members, which would include the Black Hills Community Theater performances and the symphony performances, the a cappella showcase performances, and the children's chorus performances. We would also be displaying any school events that would be happening in either theater.
Okay, so it is a combined use.
It is,
Okay.
yes. The expense is for the Performing Arts Center, but as a part of our partnership with the school district, and their usage of the Studio Theater and the Historic Theater, we would be posting their events as well.
The school board, as I understand it, has approved this sign as well.
Yes, it has. On February 4th, I pulled the wrong minutes, but I believe I pulled the March 4th, you are one of those that you have, but it was on February 4th that it was approved by the school board.
Appreciate that.
Okay.
I yield.
The chair will now recognize Alderman Steve Laurenti.
Thank you, Chair. Crystal, if you could, I have one question for you. Is this particular side of the sign, is it visible to Fifth Street? Is that part of the decision-making that the board made with this sign, or?
No, it is not visible from Fifth Street. It is visible as you come up Sixth Street or as you go down Columbus Street.
Okay, thank you.
Thank you, ma'am. I don't believe there's any more discussion on this subject. Any further? The motion is to approve the appeal. Any further discussion? All in favor say aye.
Aye.
Those opposed, motion carries. Thank you, Ms. Okay, up next is lucky number 13, introduction and first reading of ordinance number 5993 to require certain adult-oriented businesses to provide an unobstructed view in patron-permitted areas, to define knowledge as it pertains to licensees, and to delineate the hearing process for adverse action against licensees in the city of Rapid City by amending Chapter 5.70 of the Rapid City Municipal Code.
Move to approve.
Wow. We have a motion approved by Laurenti, second by Wright. Any further discussion? Chair recognizes Bonnie Peterson.
I would like to ask Mr. Johnson, I think if you can go to the podium, please, a question.
By all means.
Okay. Mr. Johnson, if between now and Monday, if you could send an email or tell us exactly what you don't like about the changes,
Okay.
that would be helpful, and what you do like.
Okay, thank you.
That would be helpful for us to make a better decision on.
To the council in whole, or?
Yes, I think it would be good, or maybe send it to the attorney's office and they would forward it. Because I would like, or the mayor, thanks, Jerry, I would, because we're going to make changes, we need to be able to look at both sides and see, what we need to do about that. So thank you very much.
Thank you.
Thank you, ma'am. Chair recognizes Joel Andine.
Thank you, Mr. Chair. I think the only change that's really going to impact Mr. Johnson's business is the door. And one of the things when we were looking at the enforcement action against Shotgun Willie's was that the only business that wasn't included in the provision that you couldn't have an area that was out of view was an adult cabaret, such as Shotgun Willie's, which seemed really odd that all the other businesses, you could not have a private room or a room that was not subject to visual inspection or was not visible to the people operating the establishment. And I believe that was an oversight in the ordinance, one that Mr. Johnson has had the advantage of now, but we felt was appropriate that based on the ordinance and the fact that if you're really trying to prevent certain types of behavior, it doesn't make sense to have a door or an area that's invisible or not visible to inspection, so that if violations occur, nobody's going to see it. So that is why we brought that amendment forward, and that clearly will impact his business because the private dance area that he has will no longer be allowed to have a door on it. The knowledge provision that he expressed concern about, that is actually the same instruction or similar language to the instruction the council was provided at the hearing. We believe that is the law because it doesn't require actual knowledge of the violation. If it required actual knowledge, then the only way you could prove a violation is if a dancer went up to the owner of the establishment, said, I am going to go on stage and I am going to violate the ordinance, and then proceeded to do so, and the owner did not prevent that. The law recognizes, and there's a lot of case law, and that's how we got the instruction provided, was that if you own a licensed establishment and there is a history of violations and there's evidence you didn't take any action to prevent those violations and things like that, that can show knowledge. It's implied knowledge. So in the future, we don't have to have the knowledge argument again where an app or a licensee is arguing that it requires actual knowledge. We made very clear in the ordinance that implied knowledge was sufficient to constitute knowledge under the ordinance. I do believe, to be honest, we looked at making it just a strict liability. If there are a certain number of violations, whether you had knowledge of it or not, your license was subject to suspension. I believe knowledge is required, but implied knowledge is sufficient under the law. So we wanted to incorporate that and make that clear so we didn't have to have that debate again if we're ever in this position. Finally, one of the things that Mr. Johnson's attorney criticized us for was that in the ordinance, we realized there was no appeal provision or really spelling out the appeal provision There was a appeal provision in the business licenses generally, but frankly, looking at it, I didn't think it provided sufficient due process for a license revocation. I think it's probably sufficient for either license issuance and renewal, which I know it may seem strange that the level of review would be different, but it is. You're not legally entitled or don't have rights to a renewal of your license, but you do have a right, once your license has been issued, to not have it arbitrarily revoked. So we wrote in a provision that's similar to the hearing we had, but not quite probably as onerous. I think that we learned some things from the hearing, so we did write in an appeal provision, and those were the 3 substantive changes. And then as I indicated in my summary, the ordinance really hasn't been significantly altered since 2003, and looking at it, there were some things we thought could be reworded, certain things we thought were unnecessary, so there was a general amount of cleanup through the entire ordinance, why it looks like there's such significant changes. That's really where we're at. I did also in my summary, I know during the hearing there was a lot of concern expressed about the definition of specified sexual activities, in particular simulated sexual acts. I would just say that I think we did not make that change for the reasons I specified. This has been upheld numerous times, so I don't want to tweak the language. And there's no way to write it in so officers don't have any discretion. That's just not workable. But if the council, based on their experience in this hearing, does not want to enforce or does not feel that they can enforce the simulated sexual acts, then I think there needs to frankly be a discussion about whether or not the prohibition on simulated sexual acts needs to be removed from the ordinance.
Thank you, Mr. Landine. Any further discussion or further questions for him? No, Jerry Wright's up next. Chair recognizes Jerry Wright.
Looks like we're queuing up for some more comments. I would just like to suggest that, as Bonnie suggested well, that the comments from Mr. Johnson or other citizens that are involved with this, to direct their comments, excuse me, to the mayor's office so that he can assimilate them into our records and send them out to us. I'm not choose words, I'm sorry about that. So they can send them out to us through our email process and then have a chance to have the attorney look at them, and then we all receive them, and then also the citizens that want to comment have a point to go to versus one of us or all of us. Fair? And also give a chance for some review by an attorney if necessary. Okay?
Thank you, sir. Mr. Mayor, would you like to speak right now?
Or choice of words. Well, I'll never live
Okay.
that one down.
We forgive you. Mr. Mayor.
Good afternoon, Mr. Chairman. I apologize. I had several people that asked me what time they should show up today, and my office advised, since it was the last item on the agenda, if they showed up at 1:45, 1 o'clock, that they would be okay, and they missed the public comment period. So I'll take the blame on that one, but I think there's a couple of speaker request forms coming your way if you'd allow folks.
Well, I'm sure we can allow some leeway. I don't think anybody has any problem with that.
And then after they're finished speaking, then I have a few comments.
Sounds good. Do you have the requests, or just want to approach the gentleman want to speak? You can just approach the podium and please identify yourself. And you have 3 minutes.
I'm John Dennis. I'm with Family Heritage Alliance. I live at 3404 Powderhorn Circle. Distinguished members of the council, I am a pastor of Black Hills Church of Christ, communications director for Family Heritage Alliance and FHA Action. As our name implies, our organization advocates for and strives to assist in growing, thriving families. I can't imagine anyone on either side of this issue who would attempt to make a case for adult-oriented businesses being a benefit to growing, thriving families. AOBs are, by their very nature, antithetical to producing healthy families. To the best of my ability to determine, the matter before the committee today in this case is the amendment to the existing AOB ordinance on the books since 2003. The proposed changes are primarily, it seems to me, about enforcement of the existing ordinance. Virtually all industries are regulated to some extent, and the regulations are only effective to the extent that they can be enforced. The FHA and our constituents respectfully ask that the Rapid City Council pass the proposed amendments to the 2003 AOB ordinance. It seems that the proposed amendments would actually benefit people on both sides of the issue who are interested in staying within the law. Thank you very much for this time to address you this afternoon.
Thank you, sir. And any further comments? Anybody else ma'am, you wish to speak? Just approach the podium, please, and identify yourself, if you would, please. That's his, not hers.
My name is Lori Messner, and I'm a business owner up in Leeds, South Dakota. And I am in support of the proposed amendments for the Ordinance 5993 that will require certain adult-oriented businesses to provide unobstructed view in patron-limited areas. I feel that the content-neutral regulations in your adult-oriented business ordinance are necessary to protect the public, the establishment, and their employees from illegal sexual and drug activity, and also solicitation of human trafficking. In January of 2011, the City Council in Leeds, South Dakota started the process of developing an adult-oriented business ordinance to regulate a proposed exotic dance bar to be located on Main Street. This AOB ordinance would supersede the already existing South Dakota state law protecting communities by restricting where an AOB, adult-oriented business, could legally operate for business within city limits. Since this establishment will be located next to a residential area, alarmed citizens formed the organization Concerned Citizens for a Safe Community and retained Stephen Westlick for legal counsel, with which my husband and I were his contact people for his group. Ideally, we were hoping that with enough statistical information provided to them by Attorney Westlick on the secondary effects of an adult-oriented business, the council would table the agenda completely. But it became apparent that they were going to proceed with a very poorly written ordinance with no enforcement planned. So we focused on trying to persuade the council to develop a more restrictive, responsible ordinance with the assistance of our attorney, Stephen Westlick. In writing, he provided evidence of numerous land use studies proving increased crime rates associated with AOBs and the need for strict regulations. In one paragraph of the letter, in a well-written opinion, he stated, law enforcement authorities across the country are faced with the challenge of conducting vice operations, oftentimes undercover, to ensure that the undesirable activity is not occurring in these establishments. These enforcement activities are costly. Further minimal regulations such as buffer zones between dancers and patrons, restrictions against VIP or private rooms, and even licensing of employees along with operators are necessary to ensure that operators do not knowingly allow their establishments to be used as places of illegal sexual activity or solicitation. So in support of what Stephen Westlick wrote to the city commissioners, I too believe a governing municipality has a responsibility to protect their community with strictly enforced regulations on adult-oriented businesses to ensure safety. I thank you all for your time and leadership in considering the proposed amendments to this ordinance. Thank you.
Thank you, ma'am. And I have no further speaker request forms. Does anybody else wish to speak? Mr. Mayor? Okay. Now we have no motion. We have a motion? A motion to approve. Okay, sorry. We do have a motion to approve. My apologies. Motions to approve. Any further discussion? All in favor say aye. Aye. Motion carries. Entertain a motion to adjourn. So moved. All in favor? Aye. We're hereby adjourned.